Turkey's Turkey's is named as an additional insured under the contractor's insurance policy. This is critical. Most insurance policies say that if a party is in contract with their insured, okay? So you're engaging a vendor. If they're in contract with your insured, the party in contract with the insured is automatically covered as an additional insured under that policy, okay? But what about the management company, okay? The management company isn't in contract with this vendor. I'm going to use snow removal as a great example of this, okay? It snows, as it does in New Jersey, unfortunately. Somebody trips and falls at the association, okay? They sue the association, they sue the management company, and they sue the snow removal contractor, okay? Now, the snow removal contractor is going to have the association covered under his policy as an additional insured automatically because, well, in most cases, automatically, because these two parties are in contract, okay? But the management company is typically covered under the association's policy. And remember, they're not in contract with the vendor. So how do you ensure that the management company is actually an additional insured under that policy? Well, your attorney should be reviewing the coverage and requiring that the contractor give you an endorsement to that policy to ensure that the management company is actually covered as an additional insured. To the extent that there's any exclusions or any issues, you should be getting endorsements, and your attorney should be reviewing them to ensure that the parties that need to be are actually covered as additional insureds. Insurance is probably one of the most crucial things, and you'll hear Drew reference it again in his discussion. Beyond the insurance coverage, though, there are other important terms that we need to make sure are included in all of your vendor contracts, which would be fee shifting. For example, if you have to sue the contractor because you have an issue, okay, you want a provision in your contract that says the contractor is responsible for paying the association's attorney's fees. Without that fee shifting provision in the contract, the chances are you're not going to be able to recover your attorney's fees if you have to litigate against this vendor. Okay? Indemnification language in the contract is also critical. Choice of law. I represent many associations, and you know, we live in North Jersey, or you might live in North Jersey, you might live in South Jersey, wherever you are, and you might be dealing with a contractor out of New York. That's fine, okay? But their standard form contract, that vendor's standard form contract may have a choice of law provision buried in their contract that says this contract is governed and controlled by New York law. Well, we're in New Jersey. Why do we want New York law governing? Okay? They might also have a provision in the contract that says if there's a dispute between the parties, everybody has to go to arbitration or everybody has to go to mediation. Well, you might not want to do that. And so why should you be tied down to that type of provision? Critical to have your attorney review the contracts. Another important provision in contracts, and then I'm going to turn it over to Drew, is, and in hiring any vendor, your management company will obviously help you with this, but the management company can't really police the vendor. It's important to have a provision expressly in the contract that says the contractor is going to comply with all relevant law, okay? You need to make sure that they're complying with OSHA. Well, I mean, you're not an OSHA inspector. So if your contract says that they're going to comply with OSHA, to the extent they don't, it's going to be their responsibility. It's not the association's responsibility. It's the contractor's responsibility to comply with law. It's the contractor's responsibility to get permits to the extent they need them. But if it's, you know, if the contractor refuses, at least you know up front that that ball is in the association's court. So really critical up front to know what you're dealing with and to protect yourself and to know if there is an issue, you can recover from the vendor's insurance policy. Okay? Drew?
I'm going to walk around because I have a hard time standing still. So Tana told you some various tactics that she uses and your association's attorneys can use to prevent the association so that if a relationship with the vendor goes south and you have to sue, how the association can at least protect itself somewhat in terms of having fee shifting if the association ultimately succeeds, having the losing contractor pay legal fees and indemnification and things like that. I'm going to talk now more about what happens. All right, you're on a board or you're a property manager for a community which is about to go through transition or has gone through is in a process of going through transition. Transition can go one of two ways. It can go peacefully and you can resolve any outstanding issues with the sponsor and developer and sign a release and the bonds are released and everyone's happy. You get a transition study from an engineer who says, all right, here's some punch list things, but by and large, your community is built properly and there are no bad issues. All right, in that case, you settle with the developer, you get some payment for some punch list items or they come out and fix it. On the other hand, transition cannot go smoothly like that. And there are some cases where either there are significant construction defects, which the sponsor will not voluntarily pay on their own for a variety of reasons. Typically, when a developer will build a community, they're not out there physically building it. They hire a general contractor who then hires subcontractors for each trade, roofing and siding and structure and landscaping and so forth, and then those subcontractors hire their own subcontractors. So there's multiple tiers of workers. And typically the problems that arise in a construction defect case is at all of the tiers. So a lot of times if it's a serious case where there are very bad defects and if it's a big community, it's going to cost millions of dollars, the sponsor or even the general contractor is not so gung-ho to pull out a checkbook and write a check to make the association whole when it was the people that they hired on their end who made the mistakes. So a lot of times they say, well, look, yes, we agree you have some problems, but, and yes, we as the sponsor, the general contractor, we quarterbacked this construction project, but we also relied on our roofers and our masonry contractors. We paid them a lot of money to make sure this didn't happen. So a lot of times if it's a bad case, they're not going to want to front the money to write basically a blank check to the association. So litigation happens. The association is in a position where it's a newer community typically, and you're not going to want to special assess your unit owners hundreds, thousands of dollars to correct deficiencies that were the responsibility and the fault of someone else. So the board is going to have to grapple with that decision. What do we do? Do we sue or do we not sue? And you should certainly rely on the counsel of your experts, your transition engineer, to make that determination, and also your counsel, your attorneys, to make that decision. Now, for my comments, though, we're going to be past that step. We're going to be at this point where the board has decided we are going to litigate. We're going to sue the sponsor and the contractors that built our place. These are very expensive lawsuits. I mean, you typically, because there's so many tiers of players that are involved in a community association construction, it's not a case where you have the association, if you're suing the developer and that's it. You have a plaintiff and a defendant. No, there's going to be dozens, typically, of defendants. You're going to have everyone in that sort of chain, that hierarchy is typically going to ultimately end up in the lawsuit. Well, even if the association does not sue all of those parties, the parties that you sue have a right to bring in additional parties that they think are responsible for the claims. So these cases quickly balloon into massive multi-party litigation matters, and it's very expensive. The association has to pay for that. Even if the association goes to a law firm, which will take the case on a contingency fee basis where they're not paying the lawyers hourly, the association's still going to have to pay experts. You're still going to have to pay an architect and an engineer to come out and do a forensic analysis of what the defects are and how to fix them. You're going to have to pay typically what we call a damages expert, who is a cost estimator who says, all right, well, yes, here are the damages and here are the defects in your community, and here's how much it's going to cost to fix that. And that's how you quantify what your claims are in a litigation. So these experts don't work on contingency fee basis. So even if you have a lawyer who does, you're still going to be spending thousands and thousands of dollars, often into the six-figure range, just for experts alone. And if you're paying your lawyers on top of that hourly, or some hybrid deal where you're paying hourly with a contingency, it's very expensive. So the board has a duty. You're fiduciaries to your other unit owners, to your community, to figure out how to spend the least amount of money to obtain the maximum amount of recovery. Now, but it's a balancing act. You know, your goal is not just to spend the least amount of money, because if you spend the least amount of money possible, that could jeopardize your ability to recover. So you've got to walk that fine line, right, in terms of maximizing your recovery. So I've thought about this a lot. I mean, this is all I do for a living, and I've sort of come to four, sort of thinking how to distill all this down into 4 points I'd like to discuss. The first point, in the context of a transition litigation, and again, when I speak about transition litigation, I'm talking about where the association has sued the sponsor and the contractors who built the place because there are defects in the construction. The very first thing that the board has to do, you've got to realize, you've got to try to detach your emotions from the litigation process. Again, this is, if there's someone that you know in your private life that does something wrong to you, and you want to sue them, and you want to make a point, and you want to, some people are litigious. People like to sue. They like to punish other people through the litigation process. As a board member, you can't do that. This is not your money to play around with, to go suing people just because you don't like the way they treated you, they told you off at a board meeting or whatever. This is not the context for that. This is not your money. You owe your unit owners and your association the duty to detach any, you could be the most litigious person in the world. You could love to sue people, but if your lawyer is telling you that the ability to recover is questionable, then no matter how much you love suing people, you should not be suing. On the other hand, if you're someone who says, "Oh, I hate lawyers. There's too many lawyers. Lawyers sue, and that's all people do. I'm tired of hearing about lawsuits, and everyone in this world is too litigious." And you personally would never file a lawsuit against anyone. You would just sort of write off any kind of damage that someone's done to you. But you live in a community where you have bad defects. Again, that's oftentimes not the right answer, not to sue. And even if your personal preference is you hate lawyers and you don't want to sue, sometimes it's the right answer, right? If you've got defendants who are solvent and you've got pockets that you can recover money from rather than having your unit owners pay, then oftentimes it's the right thing. So you've got to detach yourself from your personal preferences often. That's the number one thing, I think. You sort of look at it as a business decision. A lot of times this issue comes up in the realm of settlement, right? If a lot of times we'll have issues where I represent an association and you've got attorneys on the other side and they take the board members' depositions and maybe they're rough on the board members. The board members hate the process of having a deposition taken, and they've got a grudge against one particularly nasty attorney, and that party presents a settlement offer, and the board says, well, yeah, if it was anyone else, we'd settle, but I hated the way they treated us. I don't like the way they've conducted themselves in this litigation. We're not going to settle. We're going to take them to court. We're going to teach them a lesson. We're going to make them pay their attorney's fees. Again, you're letting your emotions guide your business decisions. It's got to be a business decision when you are on the board. Second issue I'd like to talk about is that in these types of cases, again, where litigation is expensive, you can win a construction defect litigation. You can win, but you could also lose. And this is how that happens. Typically a lawyer, or at least, well, when I go on client interviews, I can sit there and tell the people that I'm interviewing, they say, what's your track record? How many cases have you won? How many of these cases have you lost? And I could sit there and say, I've never, my whole entire career, lost a construction defect case. And everyone's like, oh, wow, this guy is Clarence Darrow. He must be great. He's never lost a case. Well, the reason I've never lost a case is because I'm only going to take a case where there are, in fact, construction defects. Construction defect law is not like where you see on TV, where you have an attorney out in the hallway while the jury's deliberating, and they're saying, oh, is the jury going to come back and say that there are no damages, that you lose? Or are they going to, it's never a win-lose situation in these types of cases. Now, again, because construction defects speak for themselves, right? The case is never going to get to a trial if there are, in fact, no defects. So, yes, you always win in the sense that a fact finder or a judge is going to come back and say, yeah, okay, sure, there are deficiencies in this construction and you're entitled to some money. But that paper that you get, that judgment, which says, yes, the association is entitled to money, it's not even worth the one single sheet of paper it's on if there are no pockets, no assets of the people that you've sued to collect on, right? So you can win, you can go to trial and you can get a big judgment, but if the contractors are insolvent, if they don't have insurance, if they're bankrupt, if you can't find them, did you really win? You spent hundreds of thousands of dollars in expert and lawyer fees and you won, but you didn't win, right? Because you're never going to have that judgment manifest into cash to the association. So the point of that story is that the next thing boards need to do and property managers need to do to maximize the recovery is you've got to work with your attorneys to pick and choose the parties that the association sues and the claims that the association brings to maximize the recovery. And here's how you do that. Tana talked about insurance. A lot of times when you have a construction defect case in the context of a condominium, the community has been built for multiple years, all right? Typically, a case is not going to happen more than 10 years after construction because in New Jersey you have what we call a statute of repose, meaning if the construction was finished more than 10 years ago, you can't sue typically. So most of these cases happen within 10 years, but they could still be, 6, 7, 8 years, depending on when transition was, after the COs were issued. And yes, maybe the developer will still be in business, maybe even some of the prime subcontractors, the prime roofing contractor, they'll still sometimes be around, sometimes not. But typically when you get down further in that hierarchy of who actually was out on the site swinging hammers, a lot of times those companies they filed for bankruptcy or they're no longer in business. You can't even find them sometimes to serve them with the complaint. So what good is a judgment against those companies unless you know how to get paid. So one of the ways that attorneys who do this type of law get paid or get their clients paid is through insurance. And this is the commercial general liability insurance that Tana mentioned. So you want to have your attorneys look at the insurance that the contractors had to A, make sure they had insurance, B, make sure there were no lapses of insurance, make sure that the insurance was actually in place during the time that they did the work, and C, look for various exclusions that Tana said, so such as an EFIS exclusion. EFIS is the exterior insulation finish system. It's that fake stucco. It's like it looks like stucco, and it has an outer coat like stucco, but it's basically styrofoam, which is attached to the building. There was a lot of litigation over the last 20 years or so relating to EFIS, because of the way the product was installed, and if it's not done perfectly, it will typically cause water damage to buildings. So insurance companies got tired of having to pay out claims for their contractors who install EFIS because it's so hard to do properly. So they started writing exclusions in their insurance policies, which say, all right, well, we'll issue an insurance policy for you, masonry contractor. So when you do your brick, or if you do your hard coat stucco, like your cementitious, the cement stucco, there will be coverage. But if you use EFIS, we're not going to cover you if you get sued. So you've got to have your lawyers look at each party, what insurance they had, and so forth, to determine what kind of claims to make and who to bring in the case. And that's an important analysis because it's tempting to often just throw the kitchen sink and sue everyone for everything. But a lot of times the claims that you make can often trigger exclusions. Another instance that comes up a lot are fraud claims. Not everyone, but very typically, clients will come to me and say, I want to sue this contractor. They defrauded me. They lied about this and they lied about that. And more savvy boards will know that in New Jersey there's a Consumer Fraud Act. And the Consumer Fraud Act, it sounds great. I mean, what a Consumer Fraud Act is, it says if contractors do not file, it basically governs their practices, their interactions with a homeowner or a community association, what requirements are in their contracts, how they conduct themselves on the site. And if they breach any of those regulations, then oftentimes you might be able to make a claim for a violation of the Consumer Fraud Act. And if you succeed on that claim, if an association wins a consumer fraud claim, under the statute, they're entitled to three times the amount of the damages. So if you sue a contractor for $10,000 because and you prevail, you go to court and you win on the consumer fraud, that verdict will most likely get tripled to $30,000 plus recovery of your attorney's fees. That sounds great. And if you've got a solvent defendant that has money to pay that, that's great. But oftentimes you don't, especially in the context of these kind of claims where the judgments are not $30,000, but they're $300,000 or $3 million. Some masonry contractor is most likely not going to have $3 million to pay your judgment. So then the question is, well, will their insurance pay that judgment? Well, often, pretty much exclusively, insurance policies exclude fraud, and it makes sense because they're not going to be a blank check so their insureds, the people that they issue policies for, can go out and defraud people. No, it's just like just like criminal conduct is. If you have a homeowner's policy and you get in a fist fight with someone, chances are that you're not going to be covered because you intentionally hurt someone, and an insurance policy is not designed to prevent that. It's designed to prevent accidents. So you've got to make sure that you pick and choose your claims wisely. So even if there could be a fraud claim, sometimes that's not the answer to pursue that claim because it could jeopardize insurance recovery. So that's my second point. My third point is, in these cases, you want to make sure you choose the right experts. These cases are very technical. Typically, the way the typical construction defect case plays out in association in the realm of condo associations is you have a developer. Developer hires an architect or a general contractor to design the building. They come up with these voluminous sets of construction plans. Then they put those plans out to bid to contractors. And you will typically have, again, like I said, you have each trade, roofing, masonry, landscape, structure, they will all have their own set of plans for that building. But then the people that get hired, those contractors will then typically hire, like I said, their own labor and so forth. Well, the reason why you have construction defects in big community associations, big condos and HOAs, is because there are so many players involved that oftentimes the right hand doesn't know what the left hand is doing. And if at the very top of that chain, the architects design a certain building system, such as stucco or a roof, to go on a very precise way to work, unless every single person in that chain has those plans and follows those plans, you often are going to have problems, right? So, and a lot of times in my cases, if I am taking, if we've sued one of the laborers who put on the roof, who was told to put on a roof by 3 tiers above them, and I'll show them the plans, and I'll say, well, did you have these construction plans during construction? And they'll say, no. I'll say, well, why not? And they'll say, well, you know, they were available, I guess, in the trailer, but look, you know, I'm a roofer, I know what I'm doing. I don't need to look at plans to tell me how to do something that I've been doing for 20 years, right? Well, you sort of do, right? And especially when this is not a small, tiny, single-family house. A lot of times these are big homes, which have very technical architectural plans, especially in areas where a roof meets another building system. So you have 2 different contractors working. The roofer's putting the roof on where it meets the siding or the stucco. That area, that location where one exterior cladding meets another, that is really vulnerable to water intrusion. And so you've got to have this coordinated installation. And because there's just so many players involved, typically you don't have that. So the point of me saying all that is that these cases are highly expert-driven, which means that when an association goes to the jury to prove its case, to prove that there are construction defects, and to prove who is responsible for those defects, you can't just have the judge or the jury assume that. You can't just say, hey, look, here's pictures of water coming in, so clearly these contractors are responsible. No, it's not like we see on TV. Every single step of the way, every single fact that you try to get the jury to believe, it's got to, when it comes to the technical aspect of building, it's got to be driven by experts. So you need to not, and experts are expensive. Good experts are expensive, but that's an area where you need to invest in. A lot of times communities will say, well, we've got a, you know, we've got this woman who lives on our, on our 2nd floor, and she's an engineer. She could be our expert. She said she'll do it for nothing because she lives here, or she'll do it for a reduced rate. And it's tempting. You say, oh, great, we're a big community. We should tap into the resources of our unit owners and let her serve as an expert. No, you can't do that. That's an area where you need an expert whose specialty is forensic building analysis in terms of, and who also not only has the substantive knowledge, but you also need experts who can walk into a room as big as this with as many attorneys as there are you guys and sit there through 2 weeks of depositions being grilled by every single attorney. You need someone who knows how to stand up to pressure and to cross-examination and so forth. So that's one area where I tell my clients, you don't want to try to save costs with your experts. You want to make sure you have the right experts. And that's not only in terms of your architect and engineering experts, but you also want to have cost estimator experts in these cases. And again, the cost estimator is very important because they basically allow you to tell the jury how much it's going to cost to fix your building. And it's from everything. And they can't just assume, they can't just say, well, a building this size, looking at these defects, I think it's going to be $3 million. No, it's got to be a hyper analysis. It's an analysis down to every single last drywall screw and every single square foot. So you got to have the right experts. And the last thing I want to talk about before we open it up to just any questions is, and this is dealing more with the property management side in terms of reducing costs and increasing recovery, is property managers play a pivotal role in these types of litigation cases. And the reason why is, think about what happens when you live in a community, you've transitioned, now the unit owners control this board. And oftentimes you'll have a new property management company. The manager that the developer used will typically be moved out, or even if they're not, you have this management company in this new community. And as the years go by and red flags start coming up. People start having leaks in their units, or they notice that there are cracks in sidewalks, or that there are a myriad of issues that you have in these communities. What's the first thing they're going to do? They're going to tell to property management. And then the property manager is going to tell the board. They're going to say, hey, we got a call that so-and-so has a leak in their unit every time it rains. We need to do something about it. And that happens enough that the board says, oh, we've got a problem. And then oftentimes that leads to litigation. Well, by the time you litigate, there's already a history of unit owner complaints for perhaps multiple years dealing with multiple different issues. The attorneys need that information. They need those complaints. They need they need this documentation of problems to support their claims. They need to tell the defendants, hey, in addition to what our experts found when they went out after we filed the lawsuit, we also have this history of all these unit owners complaining about problems. So you need to implore your property managers to take good records, great records, even before litigation. Just when they say, well, what do you mean? I mean, that's sort of, what does that mean? Good record keeping to one person could be something totally different to others. And I say it doesn't really matter if you want to do it electronically or if you want to do it the old-fashioned way. But what you need to do, though, is make sure for every single unit you have correspondence. If a unit owner complains about a leak and you get that initial email, or if it's a bigger management company which has some automated online system, you've got that record, that initial contact from the unit owner. And then if the board agrees to have that deficiency fixed, the leak patched up, you're going to have an invoice, or you're going to have some initial contact to a repair contractor. Then you're going to have an invoice from that contractor, typically, or an estimate. You want to have good record keeping for all of that. What you don't want to have is records which are not, if they don't keep them, or you just have 10 banker boxes of just documents. That's going to force the attorneys and the experts to spend time and money going through that. So you want to make sure that your property managers are well organized. And I work with property managers all the time. I'll oftentimes meet them and say, look, now we're in litigation, and here's what we're going to need from you. Here are the types of records we're going to need. Here's how we're going to need it to be organized. And good management companies welcome that, and they want to be they want to be part. I have one war story where I was in a trial about 6 years ago, and the issue. There were many issues in the case, but one of the issues dealt with when an association files a lawsuit, you're going to file a lawsuit for the cost that it's going to, for what it's going to cost to fix all of the deficiencies. But along the way, right, let's say if you have a case where leaks are bad, and you have leaks through windows. Ultimately, in this case, my case, the experts said you can't just go and caulk the leaks. You've got to remove all of the exterior cladding because the leaks are caused by a systemic deficiency. It's not just a pinpoint location where water is coming in that you could dam up. No, it's because the way the flashings interfaced with the roofing and so forth. So you couldn't just go and do a Band-Aid fix. You had to remove all of the exterior cladding, fix the damaged sheathing behind the cladding, and then put up in a new flashing system and so forth. So it was big bucks. It was a lot of money. But along the course, and it took about 5 years of this litigation. So along the course, though, of the litigation, leaks would happen in individual units. It would rain and then there would be a leak. Well, you can't wait 5 years to let water just accumulate in someone's unit for 5 years until you ultimately win the lawsuit. You've got to mitigate your damages, right? So if you've got fancy artwork or nice paint jobs or a carpet, you can't wait to make those repairs. So what we do is we do temporary repairs. We say, okay, ultimately, the whole cladding system is going to have to come down. But in the meantime, you got a leak right there. Caulk it. Fix it. In New Jersey, and in our cases, we're allowed to, in addition to seeking recovery for the full amount it's going to cost to fix, we also try to recover the amount of temporary repairs as well. Because if the defendants didn't mess up, we wouldn't have had to make those temporary repairs. So in this case, I kept saying to the property manager, you've got to keep record of those temporary repairs. Keep canceled checks. Keep costs of, keep all these records. And the property manager assured me, she said, oh, yes, I got it, no problem. And I said, you got to keep the documentation because we got to show the jury those documents which prove how much you've spent temporary repairs. So we were about 2 months before trial. And I finally called up the property manager. I said, remember I've been telling you all these years to keep those records. Now it's time to ship those records to me. And she said, all right. I said, great. So I said, should I send a courier over? She said, oh, no, you don't need a courier. I'm just going to put it in the mail. So immediately I had a red flag go up. I get a box, like one of those like FedEx boxes, which is about maybe 3 inches thick. And immediately I started getting chills because there had been dozens and dozens of repairs during the course of this litigation. And what the property manager did was, and it was my fault more because I should have been more thorough about what I wanted. Basically, just a one-page summary, how much was spent, a photocopy of the check, sort of at the bottom of the invoice, just this one page, not all the documentation we needed. And, so that we had to really, fortunately, we found out 2 months before trial. So we had time to go back to all the contractors and sort of not reproduce, but sort of compile all this documentation from all these various sources. But it took me hours and my staff hours and hours and hours and hours to do that, when I could have been focusing on trial prep, when I could have been focusing on more, on more legal issues than just administrative issues. So the point is to make sure you have good property management who can take good records and which will provide good litigation support. So look, there's many more things that I tell my clients, but those to me seem to be the biggest. Keep emotions out of it because you're on a board and it's a business. It's not your own personal matters. Winning is not always winning, right? You got to make sure winning is typically the easy part in these cases because, again, you're not going to take a case unless there are problems, deficiencies. So it's not hard to convince a jury that there is something wrong with your building when it's obvious to anyone who walks in your building that there's a problem. The hard part is getting paid on that victory, right? Third part is hire the right experts, and the fourth part is hire good property managers and tell them what you expect from them in terms of litigation support. So we've got 10 minutes. If anyone has any questions, general or specific, I'm happy to answer them. You could also, our booth is just right out here to the left. I'm happy to answer any questions you guys might have, and certainly Tana's around as well.
I may have misunderstood.
Yeah.
You mentioned something about a 10-year timeline on defect claims.
Yeah.
Could you just
Of course, yeah.
expand on that a little bit?
Of course. There are, in New Jersey, there are 2 time periods which govern when construction claims can be brought. Govern other kinds of claims, but in the context of construction, govern when construction claims can be brought. And it's sort of tricky how these claims overlap. The first is what I refer to as the 10-year statute of repose. Okay, so what that means is when construction ends on a project, that CO is issued typically is what triggers that, or substantially complete, when the building is substantially complete. You've got 10 years, the owner has 10 years to file a lawsuit relating to those construction defects, right? 10 years. And that 10-year period cannot be extended no matter what. If it's 10 years in a day, too late. If it's 10 years because the developer hid the defects from you and you didn't know, it's too late. If it's 10 years because transition took too long, right? And let's say there was some weird anomaly where you didn't control didn't transition within that 10-year period. And of course, a developer's never going to sue themselves. Still, at least the case law in New Jersey today is that it doesn't matter. 10 years is a hard and fast deadline. And the reason for that is because the construction lobby in New Jersey was strong enough to get the New Jersey legislature to pass that. And the reason why they wanted that passed was not these close cases where it's 10 years. It's because contractors were getting tired of getting sued 30 years later when all of their employees are gone, all the records are gone, and they really had they were fighting battles with both arms tied behind their backs. So the legislature said, all right, well, 10 years is going to be a good timeline. Now, it's not just that 10-year period, though. There's also a statute of limitation. Everyone's heard of that, a statute of limitation. And in New Jersey, the statute of limitation for these claims is 6 years, all right? But the statute of limitation, and it's funny, I sort of say this with a caveat because there's an issue right now in front of the Supreme Court that about when that 6-year period starts. But the way the law is, as of at least now, pending any kind of change from the Supreme Court, is that let's say the building is substantially complete. Your building is substantially complete in 2017, let's say it just finishes now. But the developer controls that building, that association, until 75% of the units sell. So let's say that doesn't happen for 3 years, right? And in 2020, transition occurs. And the association, the board gets a transition study. The general law, again, subject to what the Supreme Court does, is that your 6-year statute of limitations starts then, right? So it would start in 2020 and would end in 2026, right? Now, when you sort of overlay that 2026 deadline with the 10-year statute of repose, which started in 2017 and would expire in 2027, you would still be within that time period to file the lawsuit, okay? Because you're within the 6-year statute of limitation and you're within the 10-year statute of repose, okay? Now, let's say there is a case, using that same example I just gave. The statute of repose, that 10-year one, which cannot be extended regardless of when transition occurs, that ends in 2027. But let's say that 6-year statute of limitation, let's say transition takes longer and doesn't start until, let's say, 2025, 2 years, when you have 2 years left on the 10-year statute. You would think, logic would dictate that, well, okay, well, we didn't transition until 2025. It's not fair to hold all those years against us because the developer is never going to sue themselves. We should have 6 years. But you don't, because if it goes past that 10-year statute of repose, you're going to be in trouble. Now, there are so many caveats, there are so many sort of exceptions to the statute of limitation and when it starts, what substantial completion is. For instance, sometimes the documents between the association and the developer might have a separate date other than when the CUs are issued for the purposes of substantial completion, which is what triggers these statutes. So you got to talk to your attorneys. It's largely case-by-case basis, but the rule of thumb is you've got 6 years from transition and you've got 10 years from substantial completion, and you've got to be within both of those time frames to bring these claims.
Thank you.
Yeah. Anyone else? Yes, ma'am.
You mentioned cost estimators. We'll have it down to the screws that were used in the sheetrock.
Correct.
That, to me, sounds like the cost estimators have blueprints of everything.
They do, yeah. The way it happens is the cost estimators, well, different lawyers handle their cases differently. Some lawyers will have their engineering experts also do a cost estimation report. I don't like to do that. I like to have a separate cost estimator. It's just the way I do it. But typically what the cost estimator will do is they will have the engineer or the architect who is the expert for the association telling, generally, you have two experts. You've got the expert who says, what's wrong with the place? Here's how it should have been built, and here's how it was built, and here are the problems, and here's what damage it's causing, right? And then and another thing that same expert will do is they will say how to correct it. What needs to be done to fix the building, right?
You have two sets of like blueprints.
Yeah, you have a new expert. You have an expert who says, all right, here's what needs to be done to fix these deficiencies. Now, that opinion, that information from that one expert is given to a cost estimator who says, all right, well, this expert who represents the association is telling the world what needs to be done to fix the place. I'm going to now attribute a cost to that repair. Two experts, exactly. So they're on the same side, right? Because verifying, right, exactly. The cost estimator is relying on information that the architect and engineer gives on how to fix the place, and they put a cost to that. And then that's what I take to the jury and say, look, yes, there's problems. Here's what you need to do to fix it. And this expert's going to tell the jury how much it's going to cost to fix. So, anyone else? All right. Well, catch us. We'll be here all afternoon, so catch us if you have any questions. And thanks for sitting through, especially after lunch.